SLED agents.
I understand, but see how easy it was for him to make a phone call and turn around and give Mr. Griffin an answer.
So, okay, and the answer is SLED entered it into some database and got no matches. Did they pull the shell casings from the Murdaugh trial and compare them to the shell casings to this? And that's not what I heard. That's not what I heard. And remember now, and if you've read the sanctions motion, they misled Mr. Waters about the blood spatter for months, and misled us and misled an expert. That was the SLED lab. And when we talk about DNA in a little while, that's the context in which we are approaching this case, because we were lied to, the grand jury was lied to by SLED, and he was lied to. So I appreciate the fact he calls, and I was a prosecutor for a while. Trust, but verify when dealing with police officers.
Well, I'm sure he'd be happy to do that for you.
I think I have personally been involved in the indictment of 7 sheriffs and multiple police officers. If I had any evidence, anybody intentionally fabricated evidence, I don't play that. There is a difference between, Mr. Harper, excuse me.
Let him finish.
There is a difference between where mistakes or the 2 ships passed in the night and intentional fabrication. That might be their characterization, but that's not what the evidence reveals, and obviously that will be something that we'll discuss later on. But I will obviously look into that more, but IBAN is the database where you put guns in, kind of like the fingerprint database, and then it gives you hits whether it shows up with other crimes.
Would it show if you put in the casings or the markings from the casings?
I'm going to find out more and double check, and we're going to run this down. But again, there is no, from what I was just told by SLED, there are no leads or hits on that blackout that was used in the Allendale shooting. I promise you, though, that I'm going to find out more.
And if you got any other questions, Mr. Griffin, just email him. He'll check it out for you.
Sure will, Your Honor.
And I mean, if you want some kind of verification, I'm sure he won't have a problem giving it to you.
As long as, again, a phone call between him and an agent who has a stake in maintaining this conviction is okay for him. It's not for us. We want to see if they submitted it, what was the result? Is there a written result?
And what I'm trying to tell you, Mr. Harpooling, is just ask him. I think he will give you just that.
Okay.
And instead of just throwing all these questions at him at one time, just send him an email. And if you want something verified, tell him. Do you have a report to that? I understand you being distrustful. I got it. But if he doesn't know what you want, he can't give it to you.
We'll be explicit. Thank you, Your Honor.
Yeah,
All right, let's go back now. I'm sorry about that, Mr. Orders. Let's go back to the defendant's prior testimony in his retrial.
Sure, and just to start out, he said at 1023, I said new case, and I think he's parsing my words a little closely when I'm talking about Your Honor's reconsideration of a ruling. It's still the same indictment. It's still the same testimony that's under oath. It's still the same evidence that's going to be presented. It is the same case. And while Tucker is a bifurcated proceeding, it still was a brand new evidentiary proceeding de novo in that particular case. So I think Tucker is still applicable. Ultimately, again, I think that the appropriate solution is going to depend on your Honor's parameters as we get to that financial evidence. But ultimately, the Supreme Court said, we agree with the state that under the facts and circumstances in existence in the first trial, the trial court acted within its discretion in deciding not to exclude the evidence under 404, and went on to say, we hold the trial court acted within its discretion in admitting some evidence of his financial crimes. So that issue was in play. So it is not going to give them sort of a complete out, unlike Harrison, which I believe was a completely false confession that was played on TV and for everybody to see prior to trial. The financial crimes, according to the Supreme Court, were appropriately in play. The only issue was to an extent which Your Honor and the parties can clearly circumscribe that based on Your Honor's ultimate ruling as to those issues.
Okay. All right. I did, Mr. Barber.
Your Honor, just very briefly, we anticipated the argument Mr. Waters just made on page 9 of our response brief. It is under Harrison, it is the state's burden to show that its action did not induce the testimony. So this idea that you can parse out that they could have introduced some unknown quantum of financial evidence, we don't know exactly what would have been admissible or not, and maybe that quantum would have been admissible and therefore not triggered Harrison or Simmons. It's the state's burden to say that what they introduced did not compel his testimony, and simply saying that we perhaps could have introduced something is not sufficient to meet that burden.
Okay. All right. Well, I've read the case law. I've read the statute in this case, and I think it's pretty clear. A criminal defendant's testimony from a first trial is admissible at a retrial in the same case, and that is from 1911-50. The testimony of a defendant in a criminal case shall not afterwards be used against the defendant in any other criminal case. That is, our Supreme Court interpreted 1911-50 narrowly, and it limited its protection to the use in a different criminal case, not the same case. So I believe that his testimony may come in under 804. I've got B1 or A1, I think it's B1, or for impeachment purposes. The court does not find the defendant's argument prevailing. I think you rely heavily on Harrison versus U.S., where the defendant was forced to testify as a result of the prosecution using illegally obtained confessions by the defendant. Here, the defense argues that the evidentiary decision of the trial judge to allow evidence of the financial crimes coerced the defendant into testifying. However, I went and looked at the ruling again from our Supreme Court. The court ruled that the evidence of the financial crimes in this case is admissible in the new trial, so long as it is probative to the murder.